To order, please stand to salute the nation's flag. I pledge allegiance to the flag of the United States of America and to the republic
for which it stands, one nation, under God, indivisible, with liberty and justice for all.
In attendance this evening are Supervisors Fisher, Aguizio, Fleer, Cassiola, and Sababic. In addition, Township Engineer Dan Dizeroth, Attorney Gretchen Moore, and Carol Farkas. Before I begin, I'd like to announce that we held an executive session on August 9th at 5 p.m. for legal advice for settlement negotiations on pending litigation related to the Bernard Schultz appeal. Moving on to 147-2021. Consider appealing the ruling of the Court of Common Pleas in the land use appeal filed by Jeffrey O'Maddock at 349 Grange Road, McDonald, PA, and any other matters that come before the board. This item was tabled at the Monday, August 3rd, 2021 monthly meeting of the Cecil Township Board of Supervisors. This special meeting was duly advertised on August 9th, 2021. I'll let the board comment and then I'll open it up for public comment. Please make sure you're speaking into your microphone because we are trying to live stream.
Yeah, I know was interested in tabling this to look further into it, and I couldn't find any reason to look at this and not set precedent. And I agree with what the solicitor says about it setting precedent. I think, though I know we'd all like to help Mr. Maddock. I think that precedent that would set would be devastating for us in the future down the line. So I could not find anything. I talked to Dan again, and there's just no way to say this is a unique circumstance and to say to be comfortable that it wouldn't set precedent.
So I'm going to ask that you hold all comments. I will open it up for public comment before we take a vote. So what you're asking that we appeal? So you're saying?
Well, I just wanted to make that comment.
Yeah.
That was the reason why I asked to try to get this table to look further into this to see if there was some mechanism for relief, and there just isn't. I just don't see any. Couldn't find any.
Okay. Any other board comments before I open it up for public comment?
Yeah, I thought of it many hours as well, and still have determined that we shouldn't be involved in any more appeals. So this should not be appealed any further.
Okay.
Again.
Any other board comments? I'm going to go ahead. Do you want to step to? I just ask that you step to the microphone and state your name and address for the record, please.
Jeff O'Maddock, 349 Grange Road. I mean, this is a unique situation we're in here. Like I said, I'm just trying to get a place for my daughter to live. I had a landslide. I didn't know this was all going to happen. It wasn't supposed to happen this way, but it did. I took this to court because I lost. I won. Like I said, I know I won, but can't you change the ordinance so nobody else can do this like I did from here on out?
That's a legitimate question. I might ask our solicitor just that one question. Based on the judge's ruling, the way he looked at it and applied our ordinance to the circumstances, is there a way that our ordinance was weak or in error that it should be amended so this doesn't happen again?
Well, I don't think the ordinance is weak in that regard, but if the board wants to consider looking at this kind of situation differently and amending the ordinance to allow for a provision. I'm sorry.
No, you're fine.
To allow for, this kind of dual use on a property, I'd caution you to think carefully about that. So
No.
More than one primary use.
I'm advocating so that if it comes up again, another judge won't rule against our ordinance. I think we should never let this happen, But, I mean, I know his circumstances is unique, but is there something in the ordinance that we could change so, and the next judge looks at it, he'll see it clearly? You know, I think he's mistaken in either his reading or interpretation of the ordinance or the application because of so much testimony at that hearing.
But am I wrong? That's not what Mr. Omadic's asking. What you're asking is for us to let you go and then tighten up our ordinance so that
That's
there
the
are.
next person, that's.
Right, that's exactly what I'm asking Gretchen.
but we
is-
The board's
can't do
worried
that.
about,
Yeah,
someone
we-
else doing this.
But we can't do that. Like, as much as I feel for your situation, our ordinance is what our ordinance is, which is there's one primary use on a parcel. We can't just look the other way knowing that that's what the situation that you have, and then say to everybody else in the community, we're gonna tighten this up to make sure that never happens again.
But that's exactly what Judge Lucas did. I mean, he read it
I
a
don't
certain
think it-
way, and he reversed the zoning hearing board's decision.
He's treating a mobile home somehow differently.
Non-conforming use.
You know, and he's treating the mobile home as temporary in nature, which in these kind of circumstances, it's not. And I think the evidence is clear that it's not temporary in nature. I mean, I think Mr. Omatic will say here today, it's not meant to be temporary. It's a place for your daughter to live. It's a home.
Correct.
Yeah, so this appeal, you have to make a decision on this appeal regardless. And if you want to make a change to somehow allow for this kind of situation, which would be a sweeping change in my opinion, that's something you could
But I
consider.
don't want to allow for that.
Could you could you also amend the ordinance to be more clear? Of course, you can always improve an ordinance. But our ordinance, as it stands right now, you know, we have to deal with it and this particular decision.
So exactly, how did he say that he considers, most people take them off their wheels if it's a mobile home. It's not a modular, it was actually on wheels, the axles, and they take
Double
the,
wide, yes, it was.
and they take the axles out. I mean, there was axles under it originally, wasn't there?
Originally, when it was brought in, yes. I'm sorry.
But I mean, say, normally you take it out, the axles, and set it on block, whether the block is a permanent foundation or not. Did he basically take the position that any mobile home brought on a piece of property is temporary?
I think that's what you have to be very concerned about. Absolutely.
I'm not an attorney, so I don't know what you guys are talking about. My attorney can't make it, he's on vacation, or he would have been here.
Yeah, I mean, I drafted my full analysis, so you have the full analysis, but there's a big concern for this board about the implications of that decision moving forward.
I mean, we're just wasting tax dollars' money, wasting my money. I don't know how far you want to take this. I know I'm getting a lot of phone calls about wasting money, taxpayer money on this. And I'm sure your phones are going to be ringing.
With all due respect, though, we can't have multiple primary uses on one parcel. And so that's really the issue. And it's not a waste of taxpayer dollars because I read through Gretchen's analysis. I also read through the judge's ruling, and I don't think that he fully understood the scenario, which is her residence is permanent. It's not, you know, something that you're going to put there for a couple of months and then pull out and leave, which is temporary. This is a permanent residence. We can't have multiple permanent residences on one parcel. We're opening ourselves up to a whole host of other issues.
What's the zoning on that property? Is it R4?
R1 to R4.
R1,
One.
correct.
Yeah.
It's a split parcel.
I guess to finish up on my question, the judge interpreted it that way. Is that an accurate interpretation to say mobile home is not considered a permanent structure?
I disagree with the opinion and the interpretation.
You referred to
In other words,
it
you
as a
disagree with the judge.
A trailer. All through the whole thing, he called it a trailer.
Can I ask you this? Do you think a judge will overturn another judge's decision? I'm just asking.
I think,
It happens all the time on
Okay,
appeal.
I'm just asking.
But, you know, all I can say to this board is you have my full analysis and the opinion. If there is no appeal, then this situation is then essentially blessed, and you have concerns about the next similar situation that comes down the pike. And how to treat it.
But assuming we didn't appeal it, and whether you subdivide or not, Dan, it's a question for you. What's the circumstance with the DEP on lots septic tie-in? You says that obviously he won't be able to do a subdivision.
So Mr. O'Matic offered to subdivide the property, which would have,
It's
that
not
was
an
our
option.
original solution to the
Yes.
whole problem. So we went round and round with the DEP on this, and I didn't believe that they would be this rigid on it myself. I made the calls myself, talked to Tim, I'm sorry, I gotta think of the name of the person. There were two people at DEP we talked to, but Tom Flanagan was the one. Tom's been there forever. And he referred me to another guy, and they emphatically said that unless there's a solution for the trailers that are there right now, if there's a comprehensive sewage plan for everything that's up there, they're not gonna allow subdivision to occur. And in Pennsylvania, if you subdivide property, you have to have an approved planning module.
Right, now, if, in the circumstance where he exists today up there on his property, if we didn't appeal, obviously our end it drops. Will he be tied into some existing system like on the house? And will the DEP come after him for that?
I don't know. Do you have approval on the current location for on-lot system from the Washington County Sewage Council? I mean, as long as the Sewage Council is blessed his current on-lot system.
Even for the mobile home, I have a system.
For the one you moved. There's no system for the other ones. They're just Wildcat, right? I mean,
There are systems for them all,
okay.
leach beds for all of them. There's only 4 left, and once they move out, I'm not putting no more back.
Right.
Sorry, not used to speaking into the mic, sorry.
That's okay, I actually we forgot to remind you anyways, no worries. I think at this point, as much as we feel for your situation, and I can only speak for myself, like, we have to be cautious of the precedent that it's gonna set going forward.
But I misunderstood it. I thought he was just pulled it on the lot and was gonna tap it into the house system. I didn't know he had an approval. I guess I missed that
An
somewhere.
approval from
That he had
whom?
For an on-lot system.
You have the application
down.
somewhere here.
So,
part of the
so we
record.
can always
Yeah,
withdraw
file
the
him, go and take
appeal.
it, right.
if-
No leach bed, nothing.
I mean, if you want, we can submit the
He
appeal
told me.
today, because we have to take the vote, and should,
He never
well,
got
I
this.
still think we have to take the appeal,
Yeah, but-
because the issue isn't necessarily your situation, Mr. O'Matic. The issue is the precedent that it sets for everybody else, which the way the ruling reads is that mobile homes or trailers are not are temporary in nature, which they're not. And then it opens us up to the potential of me saying, hey, my mother and father-in-law want to live in a trailer in my front yard, and even though I already have a primary residence on my lot, I could put another permanent, or in their eyes temporary, but a mobile home right in my front yard. It just,
Okay, there's a house on DePauli, a doctor.
I'm
He
sorry.
there's a house on DePauli Road, he's a doctor, he built a big house off to the side. He did not get a subdivision. He called it a pool house. His daughter lives in it. Now, how'd he get away with it?
I wasn't aware that, yeah, I
Do some
mean,
homework.
Yeah.
There's a
I
lot
mean-
of them in this township like
Well,
this.
you're allowed to have accessory structures subject to the accessory structure rules.
So if I put a swimming pool in, I can call it a pool house?
But if somebody sneaks a bedroom in something,
You
in a
can't do nothing about
garage
it.
or something like that, I mean, it's just, it's up to the township, they have to catch them doing it, and I mean, so,
There's a lot of them in this township, I know.
I'm, there's, of course.
Loopholes.
There's people that
Yeah.
try to circumvent the rules everywhere, I mean, but,
Then I guess my opinion is that I want us to see, to at least start the appeal or keep the appeal process alive. If he in fact, I just heard word that you really don't have an official permit, and I'm not doubting your word.
Permit for what?
To put a septic system in. for
It's
that.
in, it's been approved by the,
Well, okay, but I've heard in the meantime that it's really not, you really don't have a real approval.
yes, I
I'm not
do.
doubting- Okay, you're saying you do, so if I vote to appeal, and then, to me, if something different comes to that, seems like it could work, then I would actually make a motion to
Well-
withdraw the appeal.
Well, the appeal, though, is separate, in my opinion, from his situation. Like, we're appealing to keep the precedent from happening. If Mr. Omatic now decides that he wants to subdivide and he has the permit for the sewer, then he meets our ordinance requirements, and he can keep it and
That's what I'm
move forward
saying.
anyways.
I'm saying,
So
I'm
they're
inclined
two
to vote
s-
for the appeal,
Yeah.
but that doesn't mean we couldn't withdraw it if something
Well, we
good
wanna-
happens up there.
Wait, listen to what I'm saying, though. We want to keep the
Wait, I just want
appeal.
her answer. I mean,
Do you not
we can
agree?
always withdraw it, right?
Yeah, so repeat, because he's
Right,
not.
so, again, the appeal would be of this particular decision, and of course, the precedent it sets. If Mr. Omatic otherwise in the future complies with our ordinance, and let's say subdivides, you still don't want this decision sitting there, and you'd like to get it overturned on appeal, or the township should think about modifying its ordinance to be more clear in situations like this, or, change something in the ordinance if that's the case, to address this situation. I don't think, because I thought you asked me earlier, what if we want this kind of situation to happen? And I told you you'd have to think very carefully about allowing more than one primary use on one lot. I mean, that's, yeah, so if that's the case, and it's currently in violation, there's two things you can do. One is the appeal, and two is modify or change the ordinance moving forward. None of them would cure this situation, because this isn't a result that the board wants. You don't want to allow two primary residential structures on the same lot.
Well, I know, but
Okay.
Dan's convinced that he couldn't, probably the DEP wouldn't cooperate for him to ultimately get a subdivision. I think he's gonna make that effort. If we appeal, and I'm just saying, if it happens, then we can always withdraw the appeal, because it could be a year down the line, right, before it gets
Yes.
heard, that appeal.
Yes, we can always withdraw.
You could decide to withdraw the appeal in the future for any number of reasons. And if he's in compliance in the future, then frankly, this case has no bearing on him, because he's now in compliance.
All right, another question. I won the court, okay? Now, I'm in compliance with my septic. You should release the Uxbridge permit on that while the appeal was going on, according to my attorney.
No, we can't. Unfortunately, we can't.
Well, I talked to him, he said he'd just go to the courts and get it. He can do it that way if you want.
Then he can. But unfortunately, there's rules and requirements in the township in order to get an occupancy permit. We can't just release them. If you meet all the rules and requirements to
Well,
get the,
right now, I meet all the requirements. So you're telling me,
well, then, I don't know where she went. But like, if you meet all the rules and requirements, the occupancy permit, then we can release it.
There's a stay.
If you
There's an appeal, there'd be a stay.
yeah. So, unfortunately,
my attorney will take care of it then.
okay, thank you.
All right, so you're voting on which way?
We're gonna, yeah, so once
gonna appeal
you're
it?
seated, we'll take a vote right now. We'll take a vote right
Thank
now.
you.
Thank you.
I still say that we address the ordinance and allow this to go through. Can any additional evidence be given to the courts or the new judge? Gretchen?
Well, no, Dan has something to say, but, no, this record is closed.
Won't be more
This is the record on appeal.
Yeah, so the new judge cannot hear any more statements from you on pointing to certain facts. All he's looking
Oh, no,
at
no,
is
he
what
can
the
hear,
previous.
he's going to hear argument from me, but the record, in terms of the evidentiary record, is closed.
Right,
Right, yes, we're saying the same thing. The evidentiary record is closed.
that's witnesses, basically.
Right.
Correct.
So if they find that that mobile home can have the axles or the wheels put back on it and it removed, then we lost another appeal and the money towards that.
Not a mobile home.
Huh?
It's not a mobile home.
Well, if the wheels can be put back on and that new judge finds that finding, then it could be removed. I say if you feel that strongly about this not happening again, it needs to be addressed, cleaning up the ordinance.
There's no disagreement on
So
that,
it's
but
not,
go ahead,
it's not a mobile home?
Dan.
It's a double wide.
Is that still considered a mobile home?
I don't think so.
The other ones are those actual trailers where they
Right.
back in with the truck, and they're all in one intact unit.
The only thing that I'll say is that and maybe we have to correct the ordinance, but there is some ambiguity that I read into the ordinance. Under section 1202, number of buildings per lot, In no case shall there be more than one principal structure used for residential purposes
Dan,
on
can you
one
talk
property.
into the microphone so that it
sorry.
gets picked up?
1202, in no case there shall be more than one principal building used for residential purposes on one property, except as otherwise provided in this chapter for a mobile home park.
Park.
Park, all right, but do you consider what he has up there a pre-existing condition as a park?
In the R4 district where the mobile home park is currently located,
Right.
that's there, that's okay. It's a split zone parcel.
That's right, because it's in the R1
Correct.
section.
There's an R1 section and the R4 section. The mobile home is no longer going to be in the R4, it's now going to be in the R1.
That's why I asked that question, to clarify that.
Okay, that makes
That's
sense.
the issue, Dan. Okay, so we're going to take a vote. Do I have a motion?
So moved.
Do I have a second? I'll second. All those in favor of appealing the ruling of the common, please say aye. Aye. Opposed?
No.
It passes 4-1. And moving on to 148, 2021, consider the hiring of John Eccles as laborer with the Public Works Department. Bill and Dawn did 2 interviews. This was the candidate that Bill felt was most qualified. Do I have a motion?
I'll make a motion.
Second.
What's the rate?
Based on the contract.
Okay.
Based on the contracted rate. Sorry. It's been moved and seconded. All those in favor signify by saying aye. Aye. It passes 5-0.